Good day. We are going to discuss crimes against national security and the law of nations. When we study crimes against national security and the law of nations, you always have to relate it with Article 2 of the revised penal code. Why? Because in Article 2 of the revised penal code, it talks about one of the main characteristics of criminal law, which is territoriality, and there are a lot of there are certain exceptions, but one of the exceptions mentioned is Article 2, and one of the items mentioned in Article 2 is those crimes committed against national security and the law of nations. That is why you really have to know what are these crimes, what are the crimes covered for you to apply the exception to the territoriality principle. So meaning to say, even if the crime is committed outside of the Philippines or in a foreign jurisdiction, our Philippine court can still try and hear the case because of the extraterritorial application of the revised penal code. So most of the discussions here, especially the elements of the felonies, are taken from the book of Luis B. Reyes, and the answers to bar examination questions are taken from the UP Law Center. And at the latter part, or the summary portion, most items were taken from the compact reviewer in criminal law of Buwado. Let's start. So the crimes covered are the following: treason, conspiracy and proposal to commit treason, misprision of treason, espionage, inciting to war or giving motives for reprisals, violation of neutrality, correspondence with hostile country, flight to enemy's country, piracy, as distinguished from mutiny and qualified piracy. We are also going to talk about two special laws in relation to crimes against national security and the law of nations, and this is PD 532, or the Anti-piracy and Anti-highway robbery law of 1974, but we are only going to tackle the salient provisions regarding anti-piracy, and also Republic Act 6235 or RA 6235, an act prohibiting certain acts inimical to civil aviation and for other purposes, otherwise known as anti-hijacking law. So before we go to each particular crime, here is a 2011 bar examinations number 56. This is part of the MCQ. When committed outside the Philippine territory, our courts do not have jurisdiction over the crime of letter A, treason, letter B is piracy, letter C is espionage, and letter D is rebellion. So the answer is letter D, rebellion. So let's go now to Article 114, which is about treason. So what are the elements? Number 1 is offender owes allegiance to the government of the Philippines. Number 2, there is a war in which the Philippines is involved. Number 3, offender either levies war against the government, or letter B, adheres to the enemies, giving them aid or comfort. So an important item to discuss about an important item to take note about treason is no person shall be convicted of treason unless, number 1, on the testimony of 2 witnesses at least to the same overt act, and number 2 is on confession of the accused in open court. So there is this bar examination which was asked in 2012, and it's numbered 45. It's also an MCQ. Can the crime of treason be committed only by a Filipino citizen? Among the choices are the following. Letter A, yes, the offender in the crime of treason is a Filipino citizen only, because the first element is that the offender owes allegiance to the government of the Philippines. Letter B, the offender in the crime of treason is either a Filipino citizen or a foreigner married to a Filipino citizen, whether residing in the Philippines or elsewhere, who adheres to the enemies of the Philippines, giving them aid or comfort. Letter C, the offender in the crime of treason is either a Filipino citizen or an alien residing in the Philippines, because while permanent allegiance is owed by the alien to his own country, he owes a temporary allegiance to the Philippines where he resides. And last choice is letter D. Yes, it is not possible for an alien, whether residing in the Philippines or elsewhere, to commit the crime of treason because he owes allegiance to his own country. The answer here is letter C. So treason is not only committed by a Filipino citizen but also by an alien or an alien residing in the Philippines because of his temporary allegiance. We'll go now to Article 115, which talks about conspiracy and proposal to commit treason. Before we discuss Article 115, we have to discuss first Article 8, because Article 8 talks about conspiracy and proposal to commit felony. Conspiracy and proposal to commit felony are punishable only in the cases in which the law specially provides a penalty therefor. A conspiracy exists when two or more persons they come to an agreement concerning the commission of a felony and decided to commit it. There is proposal when the person who has decided to commit a felony proposes its execution to some other person or persons. So basically it says that the conspiracy alone is not a crime. Only if there is a certain law punishing the conspiracy to commit a particular crime that it is being punished here in our country. So what are these? Number one is Article 115, the conspiracy to commit treason as well as the proposal to commit treason. Another one is Article 136, the conspiracy to commit rebellion is already punishable, as well as the proposal to commit rebellion is already punished in our jurisdiction. And lastly is Article 141, the conspiracy to commit sedition. Take note that it only talks about conspiracy to commit sedition. The proposal to commit sedition is not included. So here is a 2011 bar examination question, number 75. A proposal to commit a felony is punishable only when the law specifically provides a penalty for it. As in the case of proposal to commit, the choices are letter A, rebellion, letter B, sedition, letter C, espionage, and letter D is highly robbery. So, referring to our discussion or to the last slide, the answer is rebellion. Again, another bar examination question, which is of the same kind as the last slide, just ask 1 year after it was asked, 2011. So here's a 2012 bar examination, number 7. Proposal to commit felony is punishable only in cases in which the law specifically provides a penalty therefor. Under which of the following instances are proponents not liable? Letter A is proposal to commit codita. Letter B is proposal to commit sedition. Letter C is proposal to commit rebellion. And letter D is proposal to commit treason. So just like what I said, take note that the proposal to commit sedition is not included or is not punished. So the answer is letter B. Another bar examination of the same kind is from 2013 or 2013, number 5. The question is, conspiracy to commit a felony is punishable only in cases where the law specifically provides a penalty. Which of the following combinations contain specific felonies under the revised penal code? So, letter A is conspiracy to commit treason, conspiracy to commit rebellion, conspiracy to commit codita, and conspiracy to commit misprision of treason. Take note that we did not talk about misprision of treason. Letter B is conspiracy to commit rebellion, conspiracy to commit codita, conspiracy to commit treason, conspiracy to commit sedition. Letter C is conspiracy to commit rebellion, conspiracy to commit sedition, conspiracy to commit illegal assemblies, and conspiracy to commit treason. Again, take note that illegal assemblies was not mentioned. And letter D is conspiracy to commit treason, conspiracy to commit sedition, conspiracy to commit terrorism. Again, terrorism was not included. And letter E is none of the above. So the correct answer is letter B. So in 2012, another bar examination question related to conspiracy. Number 9, letter B, distinguished by way of illustration conspiracy as a felony from conspiracy as a manner of incurring liability in relation to the crimes of rebellion and murder. So since the question calls for an illustration, the answer is illustration of conspiracy as a felony versus illustration of conspiracy as a manner of incurring liability. So in illustration of conspiracy as a felony, A, B, C, D, and E, they conspired to overthrow the government. For merely conspiring, they are already liable of conspiracy to commit rebellion, penalized under Article 136 of the RPC. Here, conspiracy is a crime by itself because the law penalizes the mere act of conspiring without need for the offenders to actually commit rebellion, the crime agreed upon. And as a way of illustration of conspiracy as a manner of incurring liability, A, B, and C conspired to kill X. They agreed to wait in ambush for X in a dark portion of the street where he usually passes by. For merely conspiring, they are not yet liable. Here, conspiracy is only a means of committing a crime because the law does not penalize conspiracy to commit murder. For A, B, and C to become liable, they must actually commit the crime agreed upon, which is murder. So let's go now to Article 116, Misprision of Treason. Misprision of Treason is a bar favorite. Number 1 element is offender must be owing allegiance to the government of the Philippines, and he is not a foreigner. Number 2 is he has knowledge of any conspiracy to commit treason against the government. And number 3 is he conceals or does not disclose and make known the same as soon as possible to the governor or fiscal of the province or to the mayor or fiscal of the city in which he resides. In a 1994 bar examination, number 14, it was asked, VC, JG, GG, and JJ conspired to overthrow the Philippine government. VG was recognized as the titular head of the conspiracy. Several meetings were held and the plan was finalized. JJ, bothered by his conscience, confessed to Father Abraham that he, VJ, JG, and GG have conspired to overthrow the government. Father Abraham did not report this information to the proper authorities. Did Father Abraham commit a crime? First question. Second is, if so, what crime was committed? Third is, what is his criminal liability? Answer, no. Answer to the first question, no, Father Abraham did not commit a crime because the conspiracy involved is one to commit a rebellion, not a conspiracy to commit treason, which makes a person criminally liable under Article 166 RPC. And even assuming that it will fall as misprision of treason, Father Abraham is exempted from criminal liability under Article 12, paragraph 7, as his failure to report can be considered as due to insuperable clause, as this involves the sanctity and inviolability of a confession. Conspiracy to commit rebellion results in a criminal liability to the co-conspirators, but not to a person who learned of such and did not report to the proper authorities. Sa 2010 bar examination question, number 21. Because peace negotiations on the Spratly situations had failed, the People's Republic of China declared war against the Philippines. Myra, a Filipina who lives with her Italian expatriate boyfriend, discovered email correspondence between him and a certain General Tonkatsu of China. On March 12, 2010, Myra discovered that on even date her boyfriend had sent an email to General Tonkatsu in which he agreed to provide vital information on the military defense of the Philippines to the Chinese government in exchange for 1 million and his safe return to Italy. 2 weeks later, Myra decided to report the matter to the proper authorities. Did Myra commit a crime? Explain. 3%. So the answer of the UP Law Center is yes, Myra committed the crime of misprision of treason under Article 116 of the RPC. for failing to report or make known ASAP to the governor or provincial fiscal or to the mayor or fiscal of the city where she resides, the conspiracy between her Italian boyfriend and the Chinese government to commit treason against the Philippine government in time of war. She decided to report the matter to the proper authorities only after 2 weeks. Let's go now to Article 117. It talks about espionage. There are two ways of committing espionage, and letter A is by entering without authority, therefore, a warship, fort, or naval or military establishments or reservation to obtain any information, plan, photographs, or other data of a confidential nature relative to the defense of the Philippines. So its elements are the following. The offender enters any of the places mentioned. Those places are the warship, fort, naval establishment, military establishments. And the offender has no authority, and his purpose in entering is to obtain information, plans, photographs, or other data of a confidential nature relative to the defense of the Philippines. The second way of committing espionage is by disclosing to the representative of a foreign nation the contents of the articles, data, or information referred to in paragraph number 1 of Article 116, which he had in his possession by reason of the public office he holds. So again, the offender here is not an ordinary person but a public officer, and he has in his possession the articles, data, or information referred to in paragraph 1 of Article 117 by reason of the public office he holds, and he discloses their contents to a representative of a foreign nation. So there's this bar examination question 2012 MCQ number 43. The question is, what is the crime committed by a public officer who discloses to the representative of a foreign nation the contents of the articles, data, or information of a confidential nature relative to the defense of the Philippine archipelago which he has in his possession by reason of the public office he holds? The choices are espionage, disloyalty, treason, and violation of neutrality. And as we saw earlier, the answer, of course, is espionage. Let's go now to another article, 118, inciting to war or giving motives for reprisals. There are only two elements, and number one is offender performs unlawful or unauthorized acts, and such acts provoke or give occasion for a war involving or liable to involve the Philippines or expose the Filipino citizens to reprisals on their persons or property. Article 119 is about violation of neutrality. Elements are the following. There is a war in which the Philippines is not involved. There is a regulation issued by competent authority for the purpose of enforcing neutrality, and the offender violates such regulation. Article 120 is about correspondence with hostile country. Elements are the following. Number one, it is in time of war in which the Philippines is involved. Number two, offender makes correspondence with an enemy country or territory occupied by enemy troops. And number three is correspondence is either letter A, prohibited by the government, letter B, carried on in ciphers or conventional signs, and letter C, it contains notice or information which might be useful to the enemy. Article 121 is about flight to enemy's country. The elements are the following. There is a war in which the Philippines is not involved. The offender must be owing allegiance to the government. The offender attempts to flee or go to enemy country, and going to enemy country is prohibited by competent authority. Article 122 talks about piracy. Piracy, you should take notice of this. Take a careful, you should study this because this is a bar favorite. Elements are number one, a vessel is on the high seas. The offenders are not members of its complement or passengers of the vessel. And number three, the offenders attacked or seized the vessel or seized the whole or part of the cargo of said vessel, its equipment or personal belongings or of its complement or passengers. So we have to distinguish piracy versus mutiny. Both are committed on the high seas. So in in piracy, the persons who attacked a vessel or seized its cargoes on the high seas are strangers to said vessel, while in mutiny, they are members of the crew or the passengers. And in piracy, intent to gain is essential, while in mutiny, the offenders may only intend to ignore the ship's officers, because you have to remember that in mutiny, the essence is not really robbery, which is the essence of piracy. In mutiny, there is only unlawful resistance to a superior officer or the raising of commotions and disturbances on board a ship against the authority of the commander. So Article 123 is also a bar favorite, qualified piracy. So what are the circumstances which qualifies the piracy? Is number one is whenever they have seized a vessel by boarding or firing upon the same, whenever the pirates have abandoned their victims without means of saving themselves, and number three is whenever the crimes is accompanied by murder, homicide, physical injuries, or rape. So take note that the crimes that qualifies piracy in number three are crimes against persons. So murder, homicide, physical injuries, and as we all know, rape is now considered a crime against person. So here's a 2006 bar examination, number 7, relating to piracy. While the SS Nagoya Maru was negotiating the sea route from Hong Kong towards Manila, and while still 300 miles from Apari, Cagayan, its engines malfunctioned. The captain ordered the ship to stop for emergency repairs lasting for almost 15 hours. Due to exhaustion, the officers and crew fell asleep. While the ship was anchored, a motorboat manned by renegade Ibanags from Cagayan, Claveria, Cagayan, passed by and took advantage of the situation. They cut the ship's engines and took away several heavy crates of electrical equipment and loaded them in their motorboat. Then they left hurriedly towards Apari. At daybreak, the crew found that a robbery took place. They radioed the Apari port authorities, resulting in the apprehension of the culprits. Letter A is what crime was committed, and letter B is supposing that while the robbery was taking place, the culprits stabbed a member of the crew while still sleeping. What crime was committed? Explain. So the answer is the letter A. Answer to letter A is the crime committed was piracy under Article 132 RPC, the essence of which is robbery directed against a vessel and or its cargoes. The taking of the several heavy crates of electrical equipment from a vessel at sea was effected by force and undoubtedly with intent to gain. It is at no moment that the vessel was anchored when depredated so long as it was at sea. And the answer to letter B question is the crime was qualified piracy under Article 123 of the RPC because it was attended by a killing committed by the same culprits against a member of the crew of the vessel. Another bar examination question, 2008, number 7, is the inter-island vessel MV Viva Lines 1, while cruising off Batanes, was forced to seek shelter at the harbor of Kaohsiung, Taiwan, because of a strong typhoon. While anchored in said harbor, Max, Baldo, and Bogart arrived in a speedboat, fired a bazooka at the bow of a vessel, boarded it, and divested the passengers of their money and jewelry. A passenger of MV Viva Lines 1, Dudong, took advantage of the confusion to settle an old grudge with another passenger and killed him. After their apprehension, all four were charged with qualified piracy before a Philippine court. Number 1 question, or letter A, is was the charge of qualified piracy against the three-person Max, Badong, and Bogart who boarded the inter-island vessel correct? Explain. So the answer of the UP Law Center is the charge is correct. Qualified piracy was committed when the offenders seized the vessel by boarding or firing on or boarding the same. In the problem, they even went farther by divesting the passengers of their money and jewelry. The vessel was anchored in the harbor of Kaohsiung, Taiwan, and it is submitted that the crime was committed within the territorial jurisdiction of another country. The Supreme Court has ruled that high seas contemplated under Article 122 of the RPC includes the 3-mile limit of any state. Moreover, piracy is an offense that can be tried anywhere because it is a crime against the law of nations. Letter B question is, was Dodong correctly charged before the Philippine court for qualified piracy? Answer, no, Dodong was not correctly charged with qualified piracy because committing piracy was never in his mind, nor did he have any involvement in the piracy committed. He merely took advantage of the situation in killing the passenger. He should be charged with murder since there was evident premeditation and intent to kill. So let's go now to the special law of PD 532 or the anti-piracy. The salient provision is section 2, letter D. It talks about any attack upon or seizure of any vessel or the taking away of the whole or part thereof or its cargo, equipment, or the personal belongings of its complement or passengers, irrespective of the value thereof, by means of violence against or intimidation of persons or force upon things committed by any person, including a passenger or member of the complement of said vessel in Philippine waters, shall be considered as piracy. The offender shall be considered as pirates and punished as herein after provided. So, it's similar to Article 122, Section 2D of PD 532, but here are the distinctions. In PD 532, the culprit is any person and it includes the crew members or passengers. And the situs is Philippine waters. While Article 122 or piracy, here the pirates are not the culprit are the pirates who are not crew members or passengers. They are outsiders, and the situs includes the high seas and Philippine waters. So those are the distinctions between PD 532 and Article 122. So we're going to talk about the anti-hijacking law or RA 6235 or Republic Act 6235. There are 4 acts punished in anti-hijacking law, and the first act is compelling the pilot of an aircraft of Philippine registry to change course or destination or otherwise usurping or seizing control while it is in flight. So take note that it is an aircraft of Philippine registry. The second is compelling an aircraft of foreign registry to land in any part of the Philippines or usurping or seizing control of such while it is within Philippine territory. So the second act talks about an aircraft of foreign registry. Number 3 is carrying or loading corrosive, flammable, explosive, or poisonous substances on board a passenger aircraft operating as a public utility in the Philippines. So it is a passenger aircraft. And lastly is shipping or loading such substances on a cargo aircraft operating as public utility in the Philippines in a manner not in accordance with the rules and regulations issued by the Air Transportation Office. So the fourth act is about the cargo aircraft. So here is a 2013 bar examination, number 8 MCQ. Compelling the pilot of an aircraft of Philippine registry to change its destination is letter A, grave coercion, letter B, a violation of the anti-hijacking law or RA number 6235, letter C is grave threats, a violation of the Human Security Act of 2007 or the anti-terrorism law, letter D or letter E is all of the above. The answer is letter V, obviously. So let's go now to the salient provision or to the items that you have to take note or you have to study carefully about crimes against national security and the law of nations. So number 1, you take note of treason because from what we discussed, treason is a bar favorite. So just remember the offenders in treason, it is not only Filipinos but also aliens. And the two ways of committing treason, that is the levying war against the government of the Philippines or by giving aid or comfort. And remember also the ways of proving treason. Again, remember or study carefully the conspiracy and proposal of treason, rebellion, and sedition. So, treason, the conspiracy is conspiracy to commit treason is punishable. The proposal to commit treason is also punishable. The conspiracy to commit rebellion is punishable, and the proposal to commit rebellion is punishable. The conspiracy to commit sedition is punishable, but the proposal to commit sedition is not punishable. Also, take note of misprision of treason. To put it simply, the misprision of treason is only the failure of a citizen to report as soon as possible a conspiracy against the government. And take note also of the espionage, the two ways of committing espionage. And of course, the difference or the distinction between piracy and the mutiny. Who are its offenders? In piracy, the offenders are outsiders or strangers. In mutiny, the offenders are members of the complement. And the essence of piracy is always robbery. Well, in mutiny, it may not be robbery, but only to raise commotion, to protest. And of course, the distinction between PD 532, a special law, versus Article 122. And the offenders in PD 532 is any person, including the members or the passengers, members of the complement or the passengers. And in Article 122, the offenders are only outsiders. And PD 532, it is committed only in Philippine waters, while Article 122 applies on the high seas and the Philippine waters. Take note that the crimes against national security and the law of nations are committed in times of war or in wartime, but there are felonies mentioned that these are committed not only in times of war but also in times of peace. And there are four felonies. My acronym is PIVE, number 5, but it's actually spelled as PIVE, letter P, P-I-V-E. And that is piracy, can be committed in times of peace. Letter I is inciting to war and giving motives for reprisals, can also be committed in times of peace. Letter V, violation of neutrality, committed also not only in times of war but also in times of peace. And lastly is espionage, committed not only in times of war but also in times of peace. So these are the four felonies. Acronym is PIVE, Bisaya of 5. And take note of RA 6235. There are 4 acts. The number 1 pertains to an aircraft of Philippine registry. Take note that it must be in flight. Number 2 is an aircraft of foreign registry. It need not be in flight. And number 3 is the public utility passenger aircraft. The mere carrying of prohibited substance is criminal, while in number 4, the public utility cargo aircraft, non-compliance with the ATA rules, the Air Transportation Office rules and regulations constitutes the criminal act. So that's the end of this presentation. If you like, please click like and subscribe. And if you have comments, please leave below, and see you on the next presentation, which is crimes against the fundamental laws of the state. Thank you and good day.